Welcome to our continuing YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we are going to be discussing why most demand letters seeking additional severance from one's former employer are not effective. The fact of the matter is that especially where there have been a lot of terminations in the past, the employers recognize where most demand letters come from and where they go. They don't outline anything specific. They simply rely on common law applications suggesting that typically this is what should be provided, and that if you don't provide it, we're threatening you with a lawsuit. The fact of the matter is most of those lawsuits do not come to fruition. And secondly, even when they do result in a lawsuit being filed, the employers typically are of the position that the former employee is going to cave rather quickly because the cost of litigation is that substantial. And if they show some seriousness, not by submitting a demand letter, but by filing an actual lawsuit that really shows commitment, that yes, they'll jump it up a bit, and then what they'll do is they'll simply close down that action and be done with it. Other employers might come back with some slight offering and close it down also very quickly. But overall, demand letter may suggest a bigger payout, but typically it results in a minimalist payout. And the reason I say that is because the focus is so much on obtaining exclusively something that comes from the common law and comes from case precedent and doesn't focus on anything else. What needs to be done from a standpoint of the employee is to find other hooks within which to aggressively challenge the employer and to have the ability to pursue the employer aggressively, succinctly, and for considerably more money across the board. That makes them more receptive to the demands of that particular employee as to making the payment out there. There has to be more than this being a one-off where there is an inappropriate calculation of severance pay, where severance pay is known to have a fair degree of ambiguity, and the employer is able to say, well, I'll give you some more, sign off on your non-disclosure agreement, confidentiality agreement, let's close it off, settle it out. Here's a bit more money. Nobody hears about it anymore. I don't get burned at all on any side. And that is because the whole structure of the demand is set up in a way that doesn't allow the former employee to more aggressively pursue the matter as against their former employer. And because of that, the employer who is already paying substantial amounts of money to their lawyers is better off in many respects, at least in their opinion, especially in their arrogance oftentimes, to not set a bad precedent amongst their former employees and take a hard line. So everybody knows that they've taken a hard line, and everybody understands, at least the hope is, that they are proceeding in that course, and everybody should expect that going forward. So you need a different tact. And that different tact means that you step away from a standardized demand letter and have different courses of attack. The fact of the matter is, oftentimes those other avenues to attack, the other hooks might not be available. But where they can be discerned and where they are available, they should in fact be more effective tools in both getting the attention of the employer and effectuating a better result for the former employee so as to get the compensation that they want, because the fact of the matter is, from the standpoint of the employer, there becomes far more that could potentially be lost, that they seek to avoid that. And because of that, they then proceed to settle more favorably from the standpoint of the former employee. That is really my perception as to how to look at these matters. It nevertheless takes that critical hook, the ability to identify those additional factors that go beyond simply case precedent and case law reflecting former situations where there was a higher level of severance pay entitlement. And that is what needs to be done if you are going to hopefully get more out of your former employer and more in line as to what, once reviewed, you should be entitled to. So I hope you found this YouTube video informative and you see why standardized demand letters by themselves might not be the most effective way to get the most out of your former employer. Thank you.